An exempt offering under Rule 505 of Regulation D of the Securities and Exchange Act of 1933 permits a company to offer and sell up to $5 million in restricted securities during any 12-month period. The company is permitted to offer those securities to an unlimited number of accredited investors and up to 35 unaccredited investors. Since the securities are restricted, an investor will not be permitted to sell those securities for at least 6 months or more. One of the major requirements is that the company is prohibited from generally advertising or soliciting those securities. In other words, a company can't put its offering on its website or in a newspaper, for example. The information required in this type of offering is fairly simple. Really, the only requirement is that the company provide certified financial statements. The company is also permitted to provide any other information it wishes to accredited investors, so long as it doesn't violate the anti-fraud provisions of securities laws. When it comes to unaccredited investors, however, the company is required to provide those investors with the same information it would as if it was filing a public offering. This could be a daunting task and very expensive. The company must also make itself available to answer questions from any potential investors. Following the closing of an offering, and once the company receives funds, it's required to file what's called a Form D with the Securities and Exchange Commission. This form is a very simple form and must be filed electronically with the SEC, and it contains summary information concerning the addresses of the owners and the stock promoters. That form must also be filed with the securities boards for each state in which an investor resides. If done correctly, this type of offering can be an economical way for a company to raise needed funds. I know this can get complicated. We can help with that.